to Behind the Scenes. I'm your host, Hector Montalvo. This show is dedicated to asking tough questions from your government officials and legal officials. Today's guest, coming back for part 2, we have attorney Thomas Mixon, and we have attorney Stephen Wright. Thank you guys for joining us again. How are you? In our last show, we were talking about the harassment, criminal harassment orders, where it takes three complaints before a complaint is issued in the court. Today I want to talk a little bit about the effects of the 209A restraining orders, which is basically a domestic relations order. Mr. Mixon, let me ask you, how often do you see these orders, or strike that, how do these orders being issued ex parte affect an individual?
Again, there's the two ways to obtain them, either the on-call judge or going before the court and getting a order of protection. Ex parte would be tremendous, especially if you had no knowledge about it. You just, I guess, be coming home from work or whatever it was, and you'd be served this restraining order. You'd be ordered to vacate the premises. Conceivably, there could be an order not to have any contact with your children, certainly not to contact the plaintiff, who usually is the woman in the relationship, although men are certainly entitled to get it as well. And you just have to turn your whole life upside down at that point until the hearing, which should take place anywhere from a week to 10 days later. So you're out of your home.
And if you violate this order, then I'm assuming, what's the longest prison term that if you violate that order, Mr. Wright?
It provides, well,
I think it's a year.
No, 2.5. 2.5.
Oh, it is 2.5 years. So for 2.5 years on an accusation on a restraining order, if it's violated, that individual could be faced with a 2.5 years prison term?
Right.
And they serve that state or
no, that would be county. There's no
county.
State provision on that. That would be a misdemeanor. The violation is a misdemeanor. But 2.5 years is a lengthy sentence, and I would imagine on a first-time violation, you wouldn't face that. But I mean, any time of jail time. Now, let me just back it up for a second. It would only be a violation. The restraining order itself, as you know, is civil. It's only if you violate the terms of it. Now, there's a number of different provisions in these restraining orders, not to contact, not to abuse. There's also a provision for support. Now, I just had a case today that I'm researching where the father had to keep the child's cell phone on for a period of time, and then eventually he let it go. And they brought that back in as a violation, and I'm looking at some cases that say there's only certain conditions that can be considered criminal, obviously, if you abuse the plaintiff. But this, along with paying support or anything like that, should not be considered a criminal violation.
Right, so you can get ordered to pay even child support on top of that, not be able to see your children, get thrown away from your home, not have any contact. What about schools? Does that affect the school records that one may be able to obtain? So if you don't have access to your children at home, do you have access to how they're doing in school?
Well, if you're ordered not to contact your children, I mean, you'd have to stay away from the school as well. I mean, you could probably, write to the principal and obtain the records, but until that order is modified, if it says to stay away from the children, that would be wherever they are.
Mr. Wright, what kind of stories do you see coming out of the courthouses with restraining orders, just to obtain a restraining order that you have heard or tried to defend against?
I've had a lot of experience with this, so it's hard to single out. As a general situation, a district court judge faced with the issue of a 209A is not going to get involved in the custody and support provisions unless there's something compelling about it. I don't see it done. I think you say, okay, you got your restraining order, go to the probate court and work out what you're going to be doing with regard to child accessibility and control, child support, whatever. But the impact is, again, heavy because, number one, the suddenness of it, especially if there's no notice or warning. Number two, I mean, it affects different people different ways. Some people are just newly to the area. Do they go rent a hotel room for 10 nights until they can get back in court? Or do they have a friend they can go to? Now, most people would go to a friend, I would assume, but the impact is terrible. The child doesn't see the parent for the 10-day period or whatever it is, and there's an impact, especially on small children, and even on fairly, well, even teenagers are impacted by something like that. I mean, it's economically, it's very, very difficult for the defendant to deal with. He's got to go out and hire a lawyer. If he's got a restraining order, he doesn't know what he can do to defeat it. I mean, as I had said earlier, that the specificity of the time, date, time, and place are very, very important. And again, I think it's important that the same judge get this case back again, and that will happen in the probate court. In the district court, you don't know who you're going to see, and that's why I think most district court judges will stay away from saying child support or custody. Or maybe custody until you can get to the probate court. But I mean, again, the impact is still immense. It's immense on any recipient of the order or any defendant.
So if the restraining order is a civil effect, and they're also being issued from the criminal side of the court system as well as the probate side?
No. But everybody who's in there has a notice with the reference to the 209A that there is a violation, and you could face up to 2.5 years if you violate it. I haven't seen that happen. I've been practicing a long time, but I have seen people go away, and and the judge saying, "I don't know what else I can do with this. The second time he's done it, bingo." And
And this would be before having their trial.
Oh, no. It would be after a trial. It would be after a day in court. But it would be after either the order's issued, and now there's an allegation as to a violation of it. And then you still got a problem if you're the defendant.
Right, especially if you are smart enough to go and know that you can get a restraining order issued from district court as well as from probate court. Now you have two restraining orders. Do the people talk in the court system? Do they have computers to let one court know that one was already issued, so it's not a duplication of a restraining order?
They'll allow the probate court to supersede the district court on the same order, wouldn't you say?
Yes. The problem I'm seeing more and more in the district court, though, is when someone wants to use it to their advantage to gain, let's just say they had an assault and battery, domestic assault and battery, and they got the restraining order. They know that if there's a future violation, even alleged, that there's a chance, and it's becoming a better and better chance, that the defendant could lose his liberty for up to 60 days pending while the case is going on. They call that a revocation of his recognizance. So if you're released on the assault and battery and said, abide by the restraining order, if there's a new allegation, the Commonwealth, through the district attorney's office, on a large majority of these cases, will say, well, we want to revoke this person's recognizance for up to 60 days. And they're held without bail. You could be a millionaire, and you're not getting out of the House of Correction until the matter's resolved, or the 60 days expires.
That could be a violation of due process right there.
That could be. And who's responsible to oversee that? I mean, we have judges. It seems like judges just handling out the restraining orders based on $25,000 to $50,000 a year. I mean, does that number show that there is a need to try to reform that particular law?
I would think so. I would think
I would think a judge would be. I think I've seen it done though. Where there's an allegation of a violation of a restraining order without due process, and in they come and take them away.
They do.
Yeah, and I think that's a problem.
Yeah, we definitely
that violates due process.
And you can't even get a bail review on that.
That's right.
On a normal case, you could get a bail. You could go down to, if it was in here in Lawrence, you could go to Salem Superior.
Yep.
But on the probation violation, that again, if you're on probation and there's an allegation that you violated the restraining order, you're held without bail while the matter's pending.
So even though all these orders, the harassment and the restraining orders, are all civil, they really, in reality, they do hold criminal implications.
Sure,
Absolutely.
any violation.
Absolutely.
Like I said, I haven't seen a violation yet of the harassment orders, but the same penalties apply.
What is one of the biggest abuses that you see in these restraining orders?
Usually, and I don't want to sound sexist here, but a lot of times it will be the female will, if there's some difficulties in the relationship, or she thinks that the boyfriend or husband is cheating on her, they'll allege a violation.
What do you think the percentage would be of the necessity of having a restraining order versus having one that's actually being abused? Do you think it's more being abused versus more people have it to abuse it versus the people that do have it that really need it? Because obviously if these orders are being abused this way, those people that really need the restraining orders, because restraining orders were designed, my belief is they're designed to protect people that are in immediate physical harm, okay? And if that's not happening, then obviously the system needs to be changed.
Everybody's swearing under the pains and penalties of perjury. Like to believe that these are valid, but we know from experience that many of them are not. I think it's impossible to guess what the percentage may or may not be as to what's valid and what isn't valid. The overwhelming argument is, of course, in some cases they are absolutely necessary, and again, I'm being redundant. The judges will err to the conservative, and they'll believe the smaller person sometime if there's alleged violence.
And with the restraining order, again, you don't need the 3 instances of harassment or abuse. So when you think about it realistically, it's usually just the man and the woman in the house, and the woman saying he threatened me or he harmed me or he hit me somehow. And I mean, who else is going to be there to witness it? So,
so that it's all based on an accusation that anyone. Well, in this particular situation, you would have to have some type of relationship.
Exactly.
Is that like a live-in relationship, or is it just a boyfriend and girlfriend, or?
It could even be a dating. You wouldn't have to. You don't have to live together.
The court would ask how long has the relationship been going on, but you don't have to be living together.
But then, obviously, the ramifications of that would be less, because if you're not living together, you're not ordered to vacate. You'd probably get an order not to abuse the person. Well, you shouldn't be abusing people anyways, but now to make it a violation, a criminal offense, which it could be anyways. I mean, if if a person strikes another person, that's a crime anyways.
And to give those viewers out there that an opportunity to understand the effect, how much would it run? I mean, basically, they would need an attorney to come in and represent them on the restraining order. What would something like this, if a restraining order was to affect an individual, what are they looking as far as expenses-wise towards to be able to be represented?
You mean attorney's fees?
Yeah.
It would depend on the attorney's hourly rate and how much time he had to put into it. And some of those you have to put a lot of time in. If you're digging for an alibi, and it can be considerable.
Right.
And then you've got to bring in an additional witness. Again, the other part of the problem is that most people involved in these situations who resort to the court do not have the financial means to protect themselves. And I find that when I've been doing it, that I've accepted less than my usual going rate because I'm concerned with the ends of justice being met, and and I know we've got an alibi. I got to bring it in, and it's as I said, sometimes more expensive than it should be, or I have to charge I would normally, because as I said, I know if the alibi witness comes in that the ends of justice will be met, and that's what we're looking for.
And I think the individuals who are generally, contesting these and needing the services of the attorneys are the people who are having their jobs affected, their weapons taken from them, if they have a security clearance or something like that. Sure, they have to, they have to go all the way on. And then there's also that part of the clients who are involved in the domestic issue, but that can be taken care of in probate during the normal course of whatever the proceedings are there.
So if they have a criminal restraining order from a criminal district court, they can move that restraining over to the probate court and they can modify that one restraining. So there wouldn't be two restraining orders, just be one restraining order amended to one, right?
Well, there could conceivably still be two orders out there, but I guess if there's any overlap where
They're going to defer to the probate
the
court.
probate court,
They would.
and they're more, looking toward the issues of support, visitation. I mean, the court would really encourage, or at least the district court. I mean, still, it's civil. It's civil until there's a violation. Would encourage the parties, if they're married and their intent is to, stay separate and get divorced, to get to probate in a timely fashion.
So in the 209A restraining order, because it's civil, it would be a 209A, and if it was violated, it changes the code to a 208. Is that correct? It's
No,
a
it's still
208
a
restraining order
209A.
that becomes criminal?
No.
It doesn't, so it stays
it-
automatically 209.
Yeah.
Yeah, the 208 would be, that's
It's
more...
divorce stuff, isn't it?
Divorce stuff, right, that
It's
whole
more,
chapter.
but there's restraining orders with the criminal implication on that particular
Well, even the
208.
stuff in probate has criminal implications.
It does, and probate is civil court.
Right.
What would come out implications out of that?
Same,
Yeah.
Not violated, not
Probate judge could put you
Yeah.
away for the same violation.
same.
really.
Or he or she could use their contempt power. I think they'd go the other way, though, with...
With a violation.
Now, is there a sentencing guideline for restraining orders besides the 2.5 years in the criminal side? But what about the civil side? We've heard stories that in the civil side they can actually incarcerate you for about 179 days because that 180th day you require a jury trial. Do you know anything about that?
I've had no experience with that.
Yeah, I think that's the criminal contempt power. You'd have a jury trial, I believe. Summary contempt would be up to 60 days. I thought anything over that would require a jury trial, so I don't think you can go 180.
But it's around there, because I know that the civil court, in a lot of cases that we've gone behind the scenes to watch, we've seen judges sentence individuals to contempt of court for different issues. I mean, you can have a child support order and
Right.
still go incarcerated. If you have a restraining order and you're paying child support, and let's say you were incarcerated because you had violated that, how does that affect you? You're behind bars. How does that affect your family?
Well,
the
you'd have
kids?
to get in somehow and have it modified. Generally, they'll even, I've seen it done retroactively. If you were incarcerated, I don't think they're going to make you pay child support for that period of time that you can show that you were, incarcerated and unable to work, unless you were well off and you had other assets that were available. Then I guess it would still be going.
My experience is different in that area. I've seen people coming out of prison sentences and they said, well, you never modified it and it stays in full force and effect. I've seen that happen.
Well, I mean, it is. I mean, it would be within the discretion of the judge.
Of the judge. Well,
And for the judge to do that, he's got to say that the argument is he's depriving the family of the child support. And it's a dilemma.
it is, and it affects the children. It affects everybody in general. I mean, divorces is not a good thing. It's never a pleasant thing. But there is a lot of abuse. And speaking of abuse, to attempt to physically harm someone, how does one go about doing that? Because the wording on it, the defendant attempted to cause physical harm. Can you explain a little bit to our viewers what is cause?
Well, I guess if you're talking about causing physical harm, it would maybe be someone trying to throw something at someone and missing, or trying to strike someone and missing. something probably along those lines. I guess that would be a couple of examples, but there's probably others out there as well.
Understand, unprivileged touching of another technically is an assault and battery.
So if someone just taps you on the back of
You
the
got it.
shoulder, it's
That's right.
technically considered assault. So basically, you can't obviously, you shouldn't be putting your hands on anyone,
Right.
but, that's a good lesson to learn. If you don't want a restraining order, keep your hands off for individual people, and you won't have to deal with that. Now, on the restraining orders, the fourth of threats and duress, I mean, I'm sure that there has to be some type of way to prove that someone made a threat. Is there?
No, they'll take the victim's word for it.
So all they need is just
You've
that
got to
accusation.
disprove it if the allegation's been made.
He threatened to kill me. I mean, how many times in your life do you say so I'm going to kill you without really meaning it? But technically, that could be considered enough to get a restraining order against someone.
And no witness, is just that one person and making that accusation.
Well, I mean, if you're at home, I mean, it's going to be the husband and wife, and certainly you don't want to bring children into the mix. You wouldn't want them to testify one way or the other. So it's...
Now, we know that there's a huge immigration problem now, especially over in Arizona with the border situation. But how many do we see illegal immigrants taking advantage of these type of restraining orders to gain type of citizenship or anything like that, or public housing, Section 8 or anything like that? Or is it just...
I think they're more afraid of the courts to go looking for trouble, so to say. I see a lot coming in with unlicensed or unregistered, operating after suspension and things of that nature. So, but I mean, they do get picked up on
I
other
wouldn't
crimes.
single out illegals as utilizing these tools
No.
particularly.
Right, so there's no abuse in that aspect, where we know that our own people are basically abusing those particular
Well, they're more
systems.
familiar with it, and they're familiar with what they can accomplish with it. So I think it's probably more likely that they're the ones who would abuse it if it's to be abused. Yeah.
Now, is there any type of program in effect that will help individuals out there that may not have financial ability to pay an attorney? How can someone go about filling out the actual paperwork if they needed a restraining order, or how does someone go in and try to represent themselves against incarceration on a false accusation restraining order, or just a restraining order issue, if you want to?
Well, the plaintiff, when they come in to seek the order, is probably going to get some help from a so-called victim witness advocate.
Yeah. And every court has them.
And they'll tell them, how to fill out the forms, what probably has to be said in it in order to obtain the...
what needs to be said in it? So they have a victim advocate coach there that's basically coaching an individual what to say or write?
You'd have to say you're in fear, or you don't get the
right.
restraining order. Those are the magic words. If you're not in fear, you don't need the restraining order.
So the advocates are the ones that are using the word fear versus the actual person.
I haven't seen him say that.
I don't want to mischaracterize the advocates, but they read something and they ask questions of the advocate, and I don't know whether they're actually coaching, but they're going to say, are you afraid of him, or whatever? Or are you afraid of her? But point is that if the advocate doesn't see that they're pretty close to saying something like that, they're going to say, gee, I don't think you're going to get it.
So that's where you see the advocate sitting with the actual victim of the restraining order, putting their
Well, the
hand on
plaintiff. They're the plaintiff at that point.
They'll walk into court with them, too.
Right. And then the defendant, if he's present or not, he or she will not have anyone on their side, at least
coaching
by
him,
the
so to
court. They'd have to get their own
And I have a
advocate.
problem with that because, again, I mean, you mentioned the fact that they have someone representing them. And again, you as the defendant don't have anyone representing you. So obviously you can't go into court and seek that same type of advocate from someone in the court system
you could actually go in and make the same allegation and have that person help you. It doesn't happen in real life, but you could.
And I wouldn't say the victim witness person is advocating
No.
for them, or I shouldn't say representing them. They may advocate for the restraining
Comes
order.
pretty
but,
close to the way.
Yeah,
But
but
then
when
you
you
could
think of
have-
due process and equal protection, you would think that a man and a woman are equal in the court's eyes and under the Constitution, and you would think that they would have the same type of treatment.
Well, you both have the right to counsel. I mean, plaintiff could have their own counsel, defendant could have their own counsel. Very seldom, I'd say in probably less than 1 or 2% of these actually contested with two attorneys actually involved.
Well, with the divorce involved, you know it's coming
But then with a
sometimes.
divorce, right? If there's a divorce action.
You can see 2 lawyers there, sure.
Yeah.
Well, we're almost running out of time. Mr. Wright, why don't you give us your quick minute of your how people can reach you if they have any questions and comments or they need some legal representation. How can they find you?
Okay, my name is Stephen W. White. White is spelled W-I-G-H-T. I have law offices at 130 Parker Street in Lawrence, Massachusetts. My phone number is 978-685-2400. I have a license in both Massachusetts and New Hampshire and a lot of experience in the areas in which we're talking today. Be happy to see anyone.
And Attorney Mixon?
And my name is Thomas Mixon, that's M-I-X-O-N. My law office is 630 Boston Road in the town of Barica, and you can call me at 978-667-2300, and I'd be happy to represent either a plaintiff or a defendant who's seeking either restraining orders or orders of harassment.
Now, you've been around since the early 90s. I remember
Before
seeing you
that.
around and so on, and you're still hammering down these issues in the probate court and in the legal system.
Well, more so now in the district, and I've turned a lot of my attention into the juvenile court.
And how many years of experience do you have under your belt?
25.
And you, Mr. Wright?
40.
40 years. Wow, long time. Well, I'm glad that you guys are out there giving out good information and legal representation to all the people that may need your services. I appreciate you guys coming in, taking the time to talk to us about the harassment on Part 1 of the criminal harassment and the restraining order in the Part 2 segment. My name is Hector Montalvo. I'm your host from Behind the Scenes. Join us next time as we go behind the scenes to ask the tough questions, bring you their responses, and we let you decide. Thank you for watching.